Hello friends, welcome back. In the last video, we learned about the plaints and the money suit, how to draft a plaint in the money suit. Okay? Friends, now perpetual injunction or permanent injunction. Same in this kind of suit also, the same name of the court, OS number dash of 2024 or 2025, small cause title, plaint file on behalf of the plaintiff under Order 7, Rule 1, read with Section 26, Subsection 2 of CPC, description of plaintiff, description of defendant. Okay, now para 3. Here, in this plaint, we are dealing with immovable property. Okay, let us say I have 10 sets of site in a particular town, and the defendant, without any right and possession whatsoever, he is threatening me to dispossess from my site. Okay, then the plaintiff submits that he is the absolute owner of 10 cents of land situated in survey number so and so, with specific boundaries, situated in so and so town or village of so and so district, which has been fully described in the schedule appended to the plaint, and he has been in possession and enjoyment of the plaint schedule property for a long time, and he is claiming right and title over his property through a registered gift deed executed by his mother or father or his grandparents, or through a sale deed through which he purchased the property from its rightful owner, so and so. And however, next paragraph, the plaintiff submits that the defendant, without any right or possession whatsoever, came to the suit schedule property on and tried to dispossess me from my property, but with the help of my neighbors, we could resist the defendant from dispossessing me from my property. However, the plaintiff believes that at any time the plaintiff may come and dispossess me from my land. Therefore, the plaintiff is constrained to file this suit against the defendant for the relief of permanent injunction, restraining the defendant and his men from in any way interfering with the peaceful possession and enjoyment of the plaint schedule property of the plaintiff. Here, and next, cause of action. My dear friends, cause of action. Cause of action for this suit arose on when the plaintiff got the suit schedule property through a registered gift deed or sale deed or other instrument from so and so, and he has been the owner and possessor of the plaint schedule property. And on when the defendant tried to dispossess the plaintiff from the suit schedule property, and on such other dates which are within the jurisdiction of this honorable court. Okay? Next, my dear friend. Limitation, not necessary. If you claim any exemption under the limitation, you have to claim that exemption. Otherwise, for the purpose of court fee and jurisdiction, the suit is valued for the relief of permanent injunction notionally at rupees 50,000 or 1 lakh rupees. If you want to bring the suit in the senior civil judges court, you should increase the notional value of your relief in the plaint. Or if you want to file a suit in the district court, you need to value notionally above the pecuniary jurisdiction of senior civil judges court. Okay? And in respect of immovable properties, the jurisdiction of courts is determined by the pecuniary jurisdiction as well as territorial jurisdiction, where the property is situated and how you value your relief. Okay, and a court fee of rupees 2000 so and so paid under section so and so of AP CF and SP Act or Uttar Pradesh CF and SP Act or Gujarat CF and SP Act, as the case may be. Okay. Then 7. It is therefore prayed that this honorable court may be pleased to grant a decree in favor of the plaintiff and as against the defendant. Number 1. Restraining the defendant and his men from in any way interfering with the peaceful possession and enjoyment of the plaintiff or the plaintiff scheduled property. And number 2. And to grant cost of the suit to the plaintiff. And number 3. And to grant any other relief or reliefs as this honorable court may deem fit and proper in the circumstances of the case. Okay, my dear friends, to get a decree in a suit for permanent injunction, you need to prove 2 facts to the civil court. That is, number 1, as on the date of the suit, that is presentation of plaint, the plaintiff is in possession of the suit scheduled property. You have to prove your possession, not the title. Okay. Number 2, an actual threat. You have to prove an actual threat or an apprehension that you would be dispossessed by the defendant. Okay, that is also called cause of action. Okay. Threatening or apprehension. Then only you get suit for permanent injunction. Merely because you prove that you are in possession of the suit scheduled property as on the date of the filing suit, you will not automatically get decree. You have to prove to the satisfaction of the court that the defendant actually threatened or tried to or attempted to dispossess you from the suit scheduled property. Then only you get a relief. Okay? And court fee, my dear friends, court fee, normally in suits for permanent injunctions, the courts will not look into the title of the parties. But the Honorable Supreme Court and various high courts held that the civil courts can look into the title of the plaintiff or the defendant incidentally, not totally, not substantially, incidentally. To prove the possession of the property, if the court needs to go into the title of the plaintiff, then it can do so incidentally. Okay, not purposefully. Okay. Okay. So far, if you have any dispute over title and you file suit for injunction, then you need to pay court fee on half of the market value of your property. Okay. Then you need to mention in the facts that the defendant claiming right over my property, though he has no documents, or he is claiming right over my property through fraudulent documents, etc., etc. And therefore, I am filing this suit for permanent injunction. When it comes to court fee, for the purpose of court cause of action, you need to write down the brief facts of your from para 3 to para 5, etc., etc. Okay. And in court fee column, you need to, for the purpose of court fee and jurisdiction, the relief of permanent injunction is valued at rupees half of the market value of the plain scheduled property. That is, total value is 10 lakh rupees, for example, divided by 2, 5 lakh rupees. And the plaintiff is hereby paying the court fee and 5 lakh rupees. If you pay this, the courts may look into the title of the the plaintiff. Okay, for now that's all. Okay, in the next episode we will be dealing with another kinds of suit.